Yesterday, like most of you, I was having a conniption after finding out that Judge Beverly Cannoni had assigned herself, yeah, apparently she can do that, to Plymouth County, which is where Karen Reid's civil case has been filed. It's also where Judge Beverly Cannoni lives, and that's why, a few days after the criminal trial had ended, I started worrying that she would do this. So I posted a tweet about it and asked for some feedback from some lawyers, to which nobody responded. A good number of lay people responded though, and the general consensus was it's a different county and she can't go to Plymouth Court. And since that was the prevailing response, I sort of thought, yay, crisis averted, we can let that one go. Even though I kept turning up research that was telling me different, 'cause that's not how we do it in Massachusetts, Mr. Jackson. Apparently, in Massachusetts, the Regional Administrative Justice for Norfolk County holds broad authority to assign herself to any courtroom within the region, including Plymouth. And here's the kicker. What you and I would think is a conflict of interest is actually supported in Massachusetts. If a certain judge has a certain knowledge about a particular case, and the DA specifically requests that judge to oversee the case, then yes, this is common in Massachusetts. And it's based on the fact that because Karen Reid's trial and the pending wrongful death suit share facts, witnesses and issues, the Commonwealth likely can request assignment specific to Cannoni. This jurisdiction entanglement often prompts transfer to a judge already familiar with the material. And while assignments are nominally rotational, Cannoni has proven that she's not afraid to insert herself into high-stakes cases to maintain control. So yeah, it does look like she's inserted herself using her RAJ authority to centralise the matter in one courtroom. As RAJ Norfolk County, she has broad discretion to self-assign across counties, and this move gives the Commonwealth a continuity advantage in litigation strategy. Thus, like yourselves, I do not believe this was a coincidence. What Arnie Bev's doing isn't just offensive to due process, it's calculated. When a judge inserts herself into both the criminal and the civil branches of the same case, especially with her track record, that's not normal. That's not coincidence, that's consolidation of power. And it's totally normal in Massachusetts. There's no conflict of interest or the usual things that all of us were thinking. The fact that she has this sort of power is totally soul-crushing. What we're seeing isn't just corruption, it's calculated institutional sadism. They dragged Karen Reid through 2 years of character assassination, digital forensics smokescreens, and a judge who might as well have worn a prosecution pin on a robe. And now they're doing it again to Aidan Carney, the guy who literally exposed it all. Meanwhile, the people who lied to the feds, the jury, and the public are playing victims on TV while their hand-picked judge slithers into the civil case like it's some kind of prize. And we're supposed to believe this is about law and order? No, it's not. It's Meatball using the courts like a mafia enforcer, and he's basically sending the message, if you cross us, we'll bankrupt you, indict you, and assign our own judge to make sure you never get out clean. Oh, and here's the kicker. Guess who gets to decide whether or not she's recused if the defence decides to try to file a motion to recuse her? Yeah, it's basically the same in the criminal courts. Judge Cannoni herself gets to decide whether to recuse herself or not. Yep, the whole system lets the fox decide whether it should be guarding the henhouse or not. And even if you trigger an interlocutory appeal against her own decision to recuse herself, they're very rarely ruled in your favour. And unless the appellate court agrees to step in early, you're often stuck with the proceedings under a judge you believe is compromised, until a later appeal can address the whole mess after final judgment. It's true she's not RAJ in Plymouth County, but Plymouth and Norfolk are in the same judicial region, called a judicial district, and RAJs have crossover authority when cases are interconnected or when administrative necessity allows them to travel between the courts in their region. Essentially, this means she can legally self-assign or be temporarily assigned to a civil case in Plymouth County without officially being RAJ there. It's frustrating, it's Kafkaesque, I know, but there is some good news at the other end of this, so bear with me. How the regions work, how the judicial regions work in Massachusetts, is that the Massachusetts trial court is divided into regions, and each region has a Chief Justice of the trial court at the statewide level, a regional administrative justice or justices assigned to specific counties or courts, and RAJs report to the Chief Justice and Court Administrator. And Canoni is RAJ of Norfolk, but Norfolk and Plymouth are often administratively linked, especially when it comes to overlapping civil and criminal cases like this one. And as we know, civil court assignments are usually rotational to avoid the entrenched power and bias, and Canoni's RAJ status shouldn't give her permanent control over the civil suit in another county unless 1, it's administratively justified, or 2, no other judge is available. And this is where the good news lies, well, partially good news at least. I'll let Karen's civil attorney spell it out for you.
The interesting thing about the civil case is that the case was filed in August of 2024, as we've discussed. Not a single piece of discovery was done until until they tried to take Karen's deposition in October. Until February, the next discovery tool that's used were notices of deposition of William and Janet Reed, her parents. Not an interrogatory was served, no document request was served, no depositions or documents requested of the two taverns where they were drinking. Nothing to advance those claims.
What?
So there was nothing that was done, which was part of the argument, which was, why are you suddenly urgent? Why is there suddenly an urgency to pursue deposition testimony when there's so much other discovery to be done and so much time left on the discovery deadline? And the judge, who's been specially assigned to this case, saw right through it and granted the protective orders. The interesting thing, Larry, is in Massachusetts, in the civil cases in Superior Court, where this case is pending, it's the highest trial court. The jurisdictional limits to get into the Superior Court are the most serious, either in a money amount claimed or the type of crime, if it was a criminal case.
Mm-hmm.
But in the Superior Court, judges tend to stay in a county, whether it's Norfolk County or Plymouth County or Suffolk County, for 3 to 6 months, and then they rotate out to another county. This Judge O'Shea, has been specially assigned to the civil case in the Karen Reed case. So we've got the same judge, which is very helpful because he can see and not have to learn, and get up to speed on things where he's come from a different session or a different county. So we've got a good, thoughtful, well-reasoned judge who will oversee this civil case as it proceeds through the process.
Ugh, thank heavens for that, right? While it's somewhat consoling, let's not pop the champagne just yet. Let's break it down in Massachusetts language like we're prepping for war, because let's face it, we are, right? We all know Meatball and Bev aren't going to let this go. If there's any way they can get their hands on this, they're gonna. So, the good news side of it is Judge O'Shea is currently assigned, and it's not just a regular assignment, it's a special assignment, so that's comforting. That suggests continuity, and it signals that he, not Canoni, is the presiding judge of record. Civil trial lawyers typically know which judge is managing their docket, especially if it's been ongoing for months or even years in some cases. If Karen Reed's civil attorney is saying O'Shea, he's likely correct, as of now. The bad news is, Canoni could still weasel her way in. I've found 3 possible avenues that she might use. One is administrative reassignment. RAJs can sometimes shuffle judges for efficiency or to manage caseloads. And if Canoni claims the case overlaps with a previous criminal docket, she could request it administratively. 2, motions involving former trial rulings. If motions arise that relate back to the decisions Canoni made during the criminal trial, for example, admissibility of certain evidence, etc., someone, like maybe Meatball, could argue that Canoni is the best equipped to handle it. And 3, pure power grab. Gee, that wouldn't be anything like Meatball or Canoni, would it? She doesn't need a reason if no one objects. If she angles her way into the case and no one files a motion to reassign or accuse, it sticks by default. And even if she does weasel her way in through one of these 3 methods, and defence tries to recuse her, she's the judge who gets to decide whether or not she recuses herself, so we're kind of stuck with Canoni, if she weasels her way in. But let's take a sigh of relief for now, because special assignment means the Chief Justice of the Superior Court or an administrative justice has explicitly appointed Judge O'Shea to manage this particular civil case from start to finish. It's usually done when the case is high profile or complex, there's a sensitive overlap with a criminal case, or it needs consistency in pre-trial rulings like motion practice, discovery, oversight, etc. This moves it from regular rotation and locks the case to that specific judge. So in theory, Canoni can't just walk in and claim this case like she did with trials 1.0 and 2.0. She needs a formal reassignment order, which would be highly irregular unless O'Shea retires, recuses, or the parties agree, which are obviously not going to. Any attempt by Canoni to inject herself without a procedural basis would reek of impropriety and could justify a motion to challenge. However, it's never stopped Canoni before, right? But like I said, it's not time to pop our champagne because even a special assignment isn't bulletproof. O'Shea himself might get elevated, transferred, retire, or request reassignment, or Morrissey's office could file motions designed to get Canoni back in, so there's still no guarantee that she's not going to show up again. Since these assignments are generally rotational on a 3-monthly basis, let's just keep an eye on where she goes. Because if she's still there after 3 months, then we all know what she's up to, right? Let's not get complacent. Canoni plays the long game. So does Meatball. And they both know how to move the pieces. We're currently in the calm before the storm, but trust me, if she so much as peeks at that civil docket, we ride at dawn, folks. Anyway, I hope that cleared things up for you all. The bottom line is, special assignment means Canoni's got to pull some bigger strings and something major has to happen in order for her to weasel her way back in. So that is some consolation, isn't it?